All rise. Veuillez vous lever. Please be seated. Veuillez vous asseoir.
I understand that Mr. Ophoff is now going to speak. Is this correct?
Thank you, Your Honor. Good afternoon. For the court record, too, Ms. Morgan Ashley is in the courtroom with the defense. Your Honors, I shall briefly discuss a specific issue that we take with the victim's joint submission on sentence and the submissions given yesterday by the legal representatives. As the defense was instructed to respond to these arguments during the oral pleadings, the defense waited until now to raise this objection. Your Honors, on 4 February 2021, this chamber ordered the parties and participants to submit evidence for sentencing by the 26th of February. The defense was the only party or participant to request such submissions, and in document 1780 of the court record, the common legal representatives for victims specifically notified the chamber that she would not be introducing additional evidence. The defense spent 3 weeks during this pandemic trying to meet with potential witnesses for sentencing, and it submitted 18 items into evidence. Following that, the defense then had to get all of these statements notarized pursuant to the rules of procedure and evidence. The defense worked tirelessly these past 2 months to protect its client's rights and abide by the chamber's orders. Needless to say, the defense was dismayed and perplexed as to paragraphs 99 to 115 of the victim's joint submission on sentencing. These 17 paragraphs are rife with testimonial statements, statements which do not have citations to submitted evidence to this court. As an example, paragraphs 105 and 110 are nothing but long quotations of testimonial evidence. Your Honor, through these submissions and through their submissions yesterday, they are submitting testimonial evidence from the bar. And Your Honors, with respect, this cannot be allowed. These submissions should have been signed, requested through the court, and certified through one of the mechanisms in the rules of procedure and evidence. Through these oral submissions, the defense requests the chamber to expunge from the record the testimonial evidence found in paragraphs 99 to 115 of the victim's joint submissions on sentencings, including the testimonial evidences in the footnotes, and those contained yesterday within their respective submissions. On a different topic, we wish to respond to some arguments made yesterday. We're responding to the family situation of Mr. Ongwen, discussed yesterday by the prosecution. The defense's arguments within side of its brief have shown that Mr. Ongwen and his children want to be in each other's lives, and that the mother of these children want Mr. Ongwen in the children's lives. This chamber knows the extent that the defense, the prosecution, the registry, and even the common legal representative for the victims went through to see that Mr. Ongwen maintains a relationship with his children. Mr. Ongwen made his first supervised phone call with his children in December of 2016 and proceeded therein. These calls encompassed between 15 to 16 children in total, and children from 5 different women. Your Honors, I'm going to quickly read out some stuff for the record, that these calls encompassed that, Your Honors, in 2017, Mr. Ongwen made 2 supervised calls in April, one in May, June, July, August, September, October, and December. In 2018, Mr. Ongwen made supervised calls in March, April, June, July, September, October, November, and December. In 2019, he made supervised calls in February, March, April, May, June, July, August, September, October, November, and December. Now, the pandemic caused the cessation of these phone calls. The defense currently is in the midst of ex parte litigation with the registry to make these supervised phone calls into supervised video calls, now that people can safely travel within Uganda. Again, we make these submissions to combat assertions implied by the Office of the Prosecutor yesterday that Mr. Ongwen's family situation should not be taken into account. And considering my submissions just a few minutes ago, we realize that this is not in evidence, the exact months of the phone calls. But the defense asked the chamber for its indulgence, since the defense could not have predicted the prosecution's statements yesterday, especially considering the many parties, which include the Office of the Prosecutor, who took part in this process to allow Mr. Ongwen to speak to his children. And finally, for me, Your Honors, we heard the victims talk about what their clients discussed and what their clients, the general feelings on sentencing. Now, after I was hired, I was sent down to northern Uganda, and I lived there for the better part of 11 months. And for those first 8 months, nobody knew what I did, except for the witnesses with whom I met. In January of 2016, I flew up here. It was part of the confirmation process, and my face became plastered all over the television. Suddenly, everybody in northern Uganda knew what I did. When I returned, just before the presidential elections in February of 2016, and I've told this story a dozen times, or hundreds of times, but I will give the censored version. The persons with whom I met that day, I received 2 hugs, I received 11 thank yous, and 1 FU. And during my 11 months and the preceding 3 years of spending about 4 months a year in northern Uganda, this tends to be the general consensus. Whether people are upset with what Mr. Ongwen did, these are the people with I see, not necessarily the people from Lakoti or Pajule, but the population as a whole. Between 80 to 90% of the people, now that there is a conviction especially, say that they would like Mr. Ongwen to return and return back home and be treated like the many thousands of other persons who escaped and received amnesty. And they don't want him treated like the tens of thousands of people who died in captivity in the LRA. Thank you, Your Honor. I shall turn the floor over to our counsel, Mr. Ayana Odongo.
Thank you, Mr. Opov. Mr. Ayena.
Mr. President and Your Honors, I'm highly indebted to you for this opportunity to have a last say in these proceedings. Mr. President, my role has been substantially lessened by the compelling statement that came from the horse's mouth himself. Mr. President, that is the kind of person the Victims' Council jointly think should be sacrificed almost terminally at the altar of the wrongs of the LRA as a whole and of COIN in particular. But Mr. President, Your Honors, before I begin my formal presentation, at the risk of being misunderstood for trying to relitigate what has already been covered in the judgment, permit me, Mr. President and Your Honors, to reiterate and reaffirm and put on record our apprehension and my co-counsel Chief Charles Taco and Beth Lyons and other members of my team of and complaint about the persistent fair trial violations which has characterized the proceedings before this court against our client. We take particular exception that the same violations have now seemingly overlapped into these sentencing proceedings. We deem that our client's rights as a mentally disabled defendant to have the 1,077-page judgment translated to him into a language he fully understands and speaks, that is actually was seriously violated when his request was rejected. Together with the rejection of his request for provision of extra time to enable him to read and comprehend the judgment in order for him to assist his counsel to prepare for the sentencing hearing, given that he is a mentally disabled defendant, was clearly prejudicial to Mr. Ongwen. These are violations of his fair trial rights under Article 67 of the Rome Statute. This is just for the record, Mr. President and Your Honors. Mr. President and Your Honors, at this early juncture of the introductory part of my presentation, I must take a pause and raise a red flag about a fatally serious flaw in the joint victims' brief, which unfortunately seems to have set the tone for their arguments yesterday. I'm doing this so that the chamber appreciates the tone of my presentation. On the other hand, Mr. President, based on their submission on aggravating circumstances, prosecution recommends that all circumstances taken into account, Dominic Ongwen should be sentenced to serve a prison sentence of 20 years. This recommendation is based on their argument that whereas they find no serious mitigating factors in favor of Mr. Ongwen, there are serious aggravating factors to condemn him to 20 years in prison. The defense thinks otherwise for the following reasons. Even with the minimal concession but by the prosecution, giving their reasons for it, counsel for victims have come down heavy on the prosecution. They are recommending life imprisonment, completely oblivious of the personal circumstances of Mr. Ongwen, well recognized by both the chamber and the prosecution. On our part, Mr. President and your honors, we submit that taking into account the extremely unusual individual circumstances of Mr. Ongwen, both during the charged period, even before, and now, we are of the view that Mr. Ongwen has outlived his hospitality in captivity. He should be immediately released. If he must be given any prison sentence, your honors, we humbly submit that it must be one that, after due deductions of time served in prison, shall afford him immediate release. The defense presentation shall not have a fundamental departure from the defense sentencing brief already filed in court. Therefore, we shall just highlight areas that need particular clarity, and of course, we shall also respond to the submissions of the prosecution and the Joint Counsel for Victims, much as my colleague, Mr. Boff, has already made some allusions to them. Mr. Ongwen, like the prosecution and victims, has now been asked under provisions of Article 76(2) to be heard on additional evidence or submissions relevant to the sentence in accordance with the rules of procedure and evidence. That is why, Mr. President and your honors, these proceedings under Rule 143 of the Rules of Procedure and Evidence has been convened, pursuant to Article 76, Paragraph 2. Oh, I've already mentioned that. Well, pursuant to Article 76, Paragraph 2 and 3, for the purpose of holding a further hearing on matters related to sentence. Mr. President and your honors, among the evidence Mr. Ongwen wishes to be heard on his evidence, in his mitigation, is the evidence of his good character. His good conduct, testified to by those who knew him under the hard bush conditions, should now be given its due weight and consideration at as its individual circumstances. Mr. President, apart from the clear provisions of the statute and rules of procedure, which were elaborately covered in our defense sentencing brief, and over which there seem to be no serious disagreements, the defense proposes to start with highlighting some principles that should guide your consideration for sentencing. We shall also discuss some matters of the interpretation of the provisions of the relevant provisions of the statute and rules of procedure and evidence. Mr. President, what court should consider when balancing between mitigating and aggravating circumstances shall be discussed in the course of our submission. We can only repeat what has already been stated by the prosecution and the joint victims, that chambers of this court have already determined that the primary purpose of sentencing at the ICC are retribution and deterrence. That a person was convicted as an example, there's some mishap here. It is a clear principle, Your Honors, that conduct after the offense must not be taken into account for its own sake. It must be for a factor to be considered as aggravating circumstance or factor. There must be a sufficiently proximate link between the factor and the crime or crimes that form the basis of the conviction. As an example, the crime of conscription and enlistment of children under the age of 15 and using them to actively participate in hostilities, that is under Article 82E6 of the statute, for which Mr. Ongwen was convicted. The fact that the victims were under 15 cannot as such be considered an aggravating circumstance. Further, the Appeals Chamber stated, if a trial chamber wishes to rely on facts in aggravation that could not reasonably be expected by the person, it may only do so if proper notice has been provided. For instance, in the submission of the prosecutor on sentencing, so as to follow the convicted person to defend him or herself against it. Mr. President, this brings me to refer back to what my colleague Thomas Oboth was saying about the presentation of Mr. Maloba yesterday. He dwelt on reciting many sources which are not before this court. Your Honors, the prosecution and the victim, particularly the victim, should know better that there are procedures to be followed in this court if you want evidence to be relied upon. Like my colleague said, Mr. Maloba and his colleague, Madame Masida, had all the time, and they, of their own volition, decided not to file in any evidence or statement, for that matter, to be considered in their presentation before you. So it defeats logic to hear Mr. Maloba raising sentimental issues and as if to impress the public, keep on reciting things that should not have come before you. I repeat the statement of my colleague that these documents, the statement really, raised in Mr. Maloba's presentation of yesterday are totally out of place and should be expunged from court record. Furthermore, The appeals chamber stated that if a trial chamber wishes to rely on facts in aggravation, that could not reasonably be expected. I think I've already covered this. Mr. President, the absence of mitigating circumstances in this court does not constitute an aggravating circumstance. Mr. President, although court ruled against the defense evidence of the enduring defects of the coercive environment of the LRA on Mr. Ongwen, we submit that this can nonetheless still be evaluated in the context of your function in sentencing under Rule 145, 2A of the Rules of Procedure. Surely, Mr. President, Mr. Ongwen may have failed to prove that it was more likely than not that his mental capacity may have been diminished during the charged period. But that's not to say that this chamber would not make a finding that he still indeed suffered. On the other hand, the founding prosecutor of this court, Mr. Moreno Ocampo, in the ICC prosecutor's address on the sentencing of Thomas Lubanga, said of child soldiers, and I quote, "The harm produced by this cruel treatment continue, even after demobilization. Those who didn't die as soldiers I'm sorry, Mr. President. Those, I will backtrack a bit, Mr. President. The weight given to Mr. Ongwen's key role in the crimes for which he was convicted should be considered on the background of his individual circumstances. The prosecution explicitly admits that the evidence suggests that Mr. Ongwen's years as a child and as adolescent in the LRA must have been extremely difficult, and it is unlikely that he would have committed the crimes he did in 2002, 2005, had he not been abducted on his way to school in 1987. Nothing could be clearer than this. Mr. Ongwen's individual circumstances are all to blame for the conduct he has been convicted for. From the arguments of the prosecution and the Joint Counsel for Victims, evidence of Ongwen's good conduct is not relevant. The defense invites your honors to outrightly reject this misinterpretation of the law. Mr. President, the prosecution should be hosted to its own petard after recognizing in their paragraph 2 of their submission that one circumstance sets this case apart from others tried before at the court and warrants some reduction in the sentence. The chamber found that Mr. Ongwen was abducted at the age of 9 and forced to become a child soldier in the LRA. a grim foreshadowing of the crimes he would himself commit some 15 years later. The evidence suggests Mr. Ongwen's years as a child and adolescent in the LRA must have been extremely difficult, and it is unlikely that he would have committed the crimes he did in 2005 had he not been abducted on his way to school in 1987. Mr. President, I will constantly keep on reminding you that this is the description of the person who it is suggested should now be sent for life imprisonment. Without prejudice, Mr. President, first of all, I should have said this before, but allow me to say this. The defense appreciates the enormous task performed by this court in coming to the conclusion of the case and convicting Mr. Ongwen. The rest are matters for the future and within the rights of Mr. Ongwen. But you did your part, Mr. President. And Mr. President, Your Honors, you accomplished your task with commendable aplomb. The defense appreciates and agrees that the function of this court during judgment could not have been better summarized, Mr. President, than by the chief prosecutor when she stated in her opening statement on the 16th of December 2016, and I quote, "And the focus of the ICC criminal process is not on the goodness or the badness of the accused person, but on the criminal acts which he or she has committed. This court will not decide his goodness or badness, nor whether he deserves sympathy, but whether he is guilty of the crimes committed as an adult with which he stands judged. Indeed, the goodness or the badness of the accused person, that is his conduct, must now account. We submit, Your Honors. But however, Mr. President, contrary to Article 76(1) of the statute, to the effect that the trial chamber shall consider the appropriate sentence by taking into account the evidence presented and submissions made during the trial that are relevant to the sentence. That is, essential elements contained in the judgment and the assessment of all factors to be considered based on this chamber's intimate knowledge of the case. The Joint Victim Counsel are trying to make statements from the bar by quoting from unsubstantiated sources. These include alleged victims and members of the communities who were never before this court, and neither have they filed any notarized statements before this court, as already stated by my colleague. They have made quotations, which we have already referred to. The defense admits that we repeat our submission earlier that they should be expunged. On the other hand, Mr. President and Your Honors, the Victims' Counsel are making a challenge against the efficacy of Matoput, a celebrated actually alternative justice system that has stood the test of time. This, Mr. President, from the bar, without the courtesy of placing any evidence before this court. The defense Mr. President, regrets to say that, contrary to the guidance in the above quoted provision, counsel for victims are approaching their role in these proceedings like a bloodhound on a frolic to catch a rogue convict devoid of the least spark of human compunction, and who should be given the ultimate penalty of the law. We caution, Mr. President and your honors, that in your evaluation, you should regard against this overzealousness on the part of the counsels for victims. They seem to completely be oblivious to appreciate any mitigating factors to merit consideration of the chamber while sentencing Ongwen. Mr. President, I was saying that I made a quotation of the founding father, the founding prosecutor of this court, Mr. Ocampo. And in our view, Mr. President, and your honors, this statement was tacit admission that the harm caused by mistreatment of children in armed conflict of a similar, albeit less exacting nature to those under consideration endured even after cessation of the war situation. The prosecution should not be allowed to change the goalpost to say in these sentencing proceedings that in the case of Dominic Ongwen, however, the situation is different. The harm produced on him by the cruel treatment under the extremely coercive LRA environment, according to them, did not continue on him during the charge period and even up to now, or that he does not have ongoing psychological trauma which still suffers. In our view, this departure is extremely unfortunate and should be ruled against them. We invite court, in particular, to take note of the prosecution's recognition that Ongwen's individual circumstance as a child soldier was a grim foreshadowing of the crimes he would himself commit some 15 years later. This statement should be given its due weight by the chamber when considering what the prosecution refers to as careful balance of Mr. Ongwen's individual circumstances against the gravity of the crime, his own key role, and the impact on the victims. Mr. President and your honors, having recognized the individual circumstances of Mr. Ongwen as stated above, the prosecution cannot be heard to water down the effect of such individual circumstances on Mr. Ongwen within only 5 years of his transition from childhood into an adult. Assuming for a moment that he transitioned into the age of criminal liability, both physically and mentally, on the stroke of midnight of the 18th birthday in 1996-1997, which we deny, your honors. Account must be taken of the 5 years of his adolescence during the charge period between 1st of July 2002 and 31st December 2005. The chamber should also take into consideration whether such individual circumstances had a bearing on the gravity of the crime, his own key role and the impact on the victims in view of the prosecution's recognition of a grim foreshadowing of the crimes he would himself commit some 15 years later. I shall now talk briefly about the unlawful behavior and the means employed to execute them. These means to execute them, Your Honors, include the weapons and soldiers put at his disposal by LRA. The back and forth question that should respectfully preoccupy the Chamber's mind throughout these proceedings should be, would Ongwen have pursued the unlawful behavior and employed the means he employed to execute the crimes if he had not been abducted and gone through the harsh and coercive environment in the LRA? If the answer is no, then this must be considered as mitigating factors. Ongwen's behavior is construed vis-a-vis the different categories of charges against him: sexual and gender-based violence, murders, attack on civilian population, his conduct at the scene of crimes, and many others. If you look at the way Ongwen behaved himself, particularly on the background that he was not acting of his own volition, he belonged to a group of people, and he was under the command of some high authorities. Would Ongwen as a person have behaved differently if he was left in a world of his own where he had to take decisions without supervision from any high authority, whose brutality knew no boundaries? Sexual and gender-based crimes. Mr. President and Your Honors, this is an area where we would indulge the Chamber to take a back seat and seriously consider the individual circumstances of Mr. Ongwen vis-a-vis the submissions of the prosecution. We first and foremost remind the Chamber of the caution with which it considered the institution of the so-called marriage in the LRA. Throughout your judgment, Your Honors, the Chamber referred to the women in Ongwen's life in the bush as so-called wives, well and correctly recognizing that, indeed, they were not his wives. It would be insensitive for Mr. Ongwen to deny that sexual and gender-based crimes are not grave crimes. Yes, they are very grave, and Ongwen accepts that. But all Ongwen is asking for is that, as Your Honors consider the gravity of the crimes committed, you should also consider his individual circumstances in the situation against the background of an institutional policy over which he had no control. When prosecution says Mr. Ongwen committed the sexual and gender-based crimes, and the so-called wives were reduced to servile status, they forget that Mr. Ongwen's status at that time was not any different. He was also serving forced labor in the LRA, being forced to participate in a war he had no capacity to understand since he was abducted. He was being subjected to LRA policy positions and standing orders that were instituted long before he was abducted, and even after his abduction, long before he became of reasoning age, and therefore he did not participate in those policy formulations, but nevertheless, he had to comply with them. Mr. President, it is not too much to ask that Mr. Ongwen's status as such should be contemporaneously considered when sentencing him. Mr. Ongwen was an adult, about 27 years old by the end of the charged period. He was also under duty to obey the strict orders regarding women possession arising from the LRA policy on woman-man relationship in the LRA. This assertion, Mr. President and Your Honors, is clearly borne out by the prosecutor's own admissions. The prosecutor had this to say about LRA's policy on abduction of women and girls in paragraph 87 of the prosecutor's amended application for warrants of arrest under Article 58 of the statute. And I quote, "For girls abducted into the LRA, a critical event was the time at which they were perceived by LRA commanders to have reached sexual maturity." As Vincent Oti admitted during the 28th December 2002 FM radio broadcast, the LRA practice was to collect girls when they are still young and have no AIDS. End of quote. Mr. President, and Your Honors, referring to the above statement in our opening statement in 2016, the prosecutor had this to say, and I quote again, "Vincent Oti's words in the radio program broadcast in December 2002, to which I have already made reference, is very clear." He said, and she quoted, "I want to assure you that the girls whom we collect and send to the bush are our mothers. We always collect the young ones who are not infected with HIV. On the other hand, among the statements made by former LRA commanders, there are those that corroborate that the policy was long-standing and predated Dominic Ongwen's adulthood or in a policy decision-making in the LRA. They identified Kony, Mr. President and Your Honors, as the source of that policy, and not Mr. Ongwen. UGA OTP P0085 stated that Kony gave orders to abduct schoolgirls, as in the attack in 1996 of Abore high school girls in the then Apache district, now Kwale district in Lao sub-region. UGA OTP P0083, a former LRA who was abducted in the early 90s and escaped in 2004, stated that younger girls were abducted because the senior officers said they were clean and without infections. Charles Abola stated that Coin said that girls from 18 years and over have diseases, and that is why he would like younger ones to be the ones to be abducted and distributed as wives. UGA OTP P007 said girls as young as 11 or 12 were abducted. Coin did not allow men to touch them or try and sleep with them before they got sent back to Coin to protect against diseases and bad spirits. Mr. President and Your Honors, after Operation Iron Fist, when Coin ordered the ranks of the LRA to be expanded with new men and women, brigade commanders also had authority to cleanse girls and distribute them far more quickly than Coin previously had allowed. This is still the statement of former LRA commanders. This underscores the fact that brigade commanders, Dominic Ongwen inclusive, did not of their own volition assume the role of abducting and distributing wives. It was a delegated authority based on clearly laid down policy. These are Mr. Ngwen's individual circumstances, Mr. President, that should be weighed in when considering an appropriate sentence for him on the issue of sexual and gender-based crimes. Consideration should be taken of the fact that man-woman cohabitation was an institutional policy of the LRA over which Ongwen had no control. The policy was to maintain discipline, and these facts which were fully given in evidence before Your Honors, to maintain discipline, avoid promiscuity, tie soldiers to the family to avoid escapes, etc., etc. Not to mention the creation of a new, actually, of the 10 Commandments purity, and to replenish the LRS ranks. Mr. Dominic Ongwen very competently expatiated on this fact of creating new Acholi. Therefore, according to Coin's policy, men were used as production machines, while the women were the production lines for Mr. Coin's pure Acholi and future soldiers. So, once a girl was abducted and distributed according to the standing orders of the LRA High Command, the rest followed as day follows night. Mr. President, an assessment should be made of a situation of an adolescent forced to live under the same roof with a woman for eternity, where there was no hope of ever getting out of the LRA situation. And the individual circumstances of Mr. Ongwen under those conditions must be considered as a mitigating factor. Yes, what he did was unlawful. It was a crime. But given the circumstances, could there be any silver line in the cloud for considering that Ongwen was overwhelmed under the circumstances to commit some of these sexual crimes? Did he have a choice? Put in the same situation, and this is the question maybe Your Honors may want to ask. Is there any evidence before Your Honors that any of the people who are in the bush who were put in the same condition as Mr. Ongwen never did exactly what Mr. Ongwen did? If the answer is yes, although the crime of another person does not constitute an excuse for the other, reason would seem to suggest that this must be taken into account, that he was put under very unfortunate circumstances. And he capitulated under those. Mr. President and Your Honors, the defense admits that the so-called wives were not exclusive, and this should also be considered. They were actually not exclusive to the person to whom they were assigned. As a matter of fact, they were held at the pleasure and behest of the LRA High Command. Actually, they were institutional property of LRA. There's overwhelming evidence on record that, for example, once it was discovered, and Mr. Ongwen talked about this, once it was discovered that the man was not treating the woman well, the woman was taken away from him and distributed to another man. This is on court record, Your Honor. On the other hand, if coveted a woman under the charge of another man, he would take her at will. In the report authored by Rhea Pire, Achama Jackson, and Mzee Kenneth Banya, which we have already referred to above, these senior commanders stated as follows. In 2001, when Joseph Kony ordered for the arrest of a total of 29 officers, namely Jackson Ray, Hilary Lagen, Livingston Nyeko, Labul, and many others, for trying to cause a mass defection, their wives were taken away. D-27 stayed in the bush for close to 27 years and was so close to Joseph Kony. On whether one had a choice when given a wife in the LRA, he testified thus: you do not have a choice. Whether you are a man or a woman, even if you are given to somebody you are not interested in. P-172 testified how, notwithstanding pleas from notwithstanding pleas from her husband to execute Bunio Chan's wife, a senior commander, because she attempted to escape, Kony nevertheless executed her. Everyone's life belonged to Kony, and even women distributed to senior commanders were still at the mercy of Kony and his decisions. D0092 stated, even the wife given to you, the woman given to you is not yours. The woman is, he, meaning Kony, says that the woman is for the movement. If, for instance, he says that the woman should go and do work in this location, and you decide, your wife, not to go, you will take away the woman from you. Mr. President and Your Honors, in relation to what is stated above, Ongwen's cruelty towards his so-called wives, in relation to Ongwen's cruelty to his so-called wives, it should be noted that the fact that there is no evidence to show that any so-called wives was removed from Mr. Ongwen or ran away and took refuge away from Mr. Ongwen. Yet, on the other hand, there is ample evidence. There is ample evidence on record by some so-called wives and other witnesses, including prosecution witnesses, that Ongwen was a good man and treated his family, including his so-called wives, well. This should go to show that although he was found guilty of cruelty and mistreatment of his so-called wives on account of evaluation of prosecution evidence, which was believed by the chamber, there is also evidence which just fell short of meeting the threshold of exculpating Mr. Ongwen. This is the kind of scenario provided for under Rule 145. Yes, he was found guilty. But at this point in time, when it behoves this court to consider his individual circumstances in the matter, court is still invited to consider that although the evidence that was provided was heavy enough to find him guilty, there were nevertheless circumstances which all considered would have found him, found that there is mitigating circumstance.
Mr. Ayena, may I ask you how much time you would need further? Because I think it would be good if we could finish before the lunch break, meaning that we could end the hearing before the lunch break. I think that should be possible.
How much time do you have, unfortunately? 25 minutes. I'll try my best. I would need maybe about 40 minutes more. 40? Yeah. I have 25 now. If I could be given 15 more, should finish it.
Yeah, I think then we should make then we should have the break now, and because this is too long then until 2 o'clock, I think. Yeah. So then we have the lunch break. I think until 2 o'clock is enough. Yeah, and then you can finish your presentation. Okay. Thank you.
Much obliged.
All rise. Veuillez vous lever.